in 1986. And the case was American Council of the Blind versus Daniel J. Burstein, Librarian of Congress. And here's what happened. The Library of Congress in the 70s began offering Playboy in Braille. Right. And not the pictures, but the reason for not the pictures was that Braille doesn't work for pictures. So that was not a discriminatory kind of situation. In any case, a congressman from Ohio was quite offended by this and decided that he was going to do something about it. And first he tried to force the Librarian of Congress to stop providing that. And the Librarian of Congress did not kneel to that. So when in 1986, when the appropriations for the Library of Congress came up, he introduced an amendment to reduce the appropriation by exactly the amount it takes to put into Braille Playboy. It didn't mention Playboy, but Burstein knew what that was all about, because he'd sort of been drug over the coals, and so he decided he eliminated it. So the American Council of the Blind went to court about it. And Burstein was individually being charged because he had made that decision. Twice, the part of the Library of Congress that does the Braille works and distributes its materials for the blind reviewed, at the request of Congress, whether this was an appropriate addition to their collection. Well, yes, it is. It met all their criteria, which nobody could argue were not appropriate criteria based on their mission. Remember what I said about your mission? And having a criteria for selection is part of that. A criteria that fits within your mission establishes what your status is in relationship to a forum for information. In fact, it was one of their most popular shows and magazines, more than Good Housekeeping. So they said, no, we aren't going to get rid of it. We can't make a content-based, viewpoint-based exception for this one title. But as soon as the House passed the bill, Burstein eliminated the title. The court ruled that that was unconstitutional. And it's interesting, its reasons. First of all, just a little history. In 1986, the concept of a limited public forum, which I described to you, was only beginning to be developed. Courts keep developing these principles as time goes on and changes in society require additional legal interpretations of how the Constitution applies. They, in fact, determined that because the money to put materials in Braille was directed towards a specific audience that's not in the general mission of the Library of Congress, that it was a subsidized service to individuals, a private benefit to individuals, those who were visually handicapped. So it was a non-public forum. But the interesting thing about this, and this is not unusual but good to be applied in this context, is that even in a non-public forum, you cannot make arbitrary, irrational decisions on the basis of content that might be offensive to someone.